Good morning. The first case coming for the court this morning is State of Ohio versus Adam Ortiz, Jr. Each party will have 15 minutes in which to present the case. For the appellant, you wish to retain some of that time for rebuttal. Let me know when you come up to the podium. I'm keeping track of the clock and I'll keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have read your briefs and we're ready to proceed when you are.
Thank you, Your Honor.
We have read your briefs and we're ready to proceed when you are.
Thank you, Your Honor. Your Honor, I'm Kenneth Worker, 0069726. I'm the attorney for Adam Ortiz, the appellant in this case. Judge, on December 19, 2016, the trial court sentenced to Adam Ortiz to community control sanctions for the first few months at CDCF. In addition to those sentences that were definite, the court imposed a potential sentence of 9 years for any community control violation that occurred. As the court showed, that was not a final sentencing, because when Ortiz violated community control sanctions on the first time, he was at CDCF and had a furlough, and when he went back to CDCF, he had some marijuana in his system. At that time, his probation officer violated him. The court found him in violation, and the court sentenced Ortiz to 30 days in the county jail, 20 days credit for time served, 10 days remaining. And so the fact is that even though he had put a potential of 9 years over Ortiz's head, at the first sentencing, he did not impose that sentence. Now, the prosecutor, the state...
Counsel, you were trial counsel, correct?
Yes, ma'am.
And on the original sentencing date, you and your client both walked out of court thinking he had 9 years hanging over his head, correct?
Judge, we walked out of court knowing there was a potential of 9 years hanging over his head.
A potential of 9. So he could have had 12, is that correct?
No, I don't. The potential that's given is a ceiling, Judge. It's not a. It doesn't work like that. So when the court sentenced you to 9 years, it's a ceiling. It's a potential sentence. And
was that plea negotiation a potential 9 years or 9 years?
The plea negotiation with the prosecutor was for 9 years. The judge on the record says potential 9 years. She could impose additional community control sanctions and other type of sentencing as well for a violation of community control. It didn't necessarily have to be those 9 years.
If it was 9 years, how would the court have gotten to 9 years but for consecutive sentences?
They couldn't have there but for consecutive sentences. But so they could not have gotten there but for consecutive sentences, but those sentences weren't executed. Those were sentences that the court had retained jurisdiction and could modify, obviously, because they did modify it, and the court believed they could modify it. In addition, the court said in their ruling that there was no ironclad agreement between the state, the prosecutor, and the judge. The trial court judge, who wasn't the original judge who sentenced Adam Ortiz, stated during the first community control sanction violation that there was no immutable agreement, that there was no ironclad agreement. And the judge based that decision upon the things that were said in court by that previous judge, who said that this is not a definite sentence. I could sentence you to something else if I chose. And it's clear from the case law that the sentence given at sentencing, if it's not executed, is a potential sentence. It's a ceiling of a sentence. It's not the sentence that you're going to be given.
It's clear from the case law that the court cannot go over that sentence. Would you agree with that?
Yes, it's a ceiling.
Okay.
Yes, correct. I would go along with that. The state did all of their cases, our cases, either where it was a definite sentence that was executed, where a person went to prison, where a person's sentence was executed, or they were cases where the defendant expressly waived the fact that there was separate animuses or merger, where they specifically waived merger. Now, one case that the states relied on was Lovett. Lovett is a case where a person's car was towed and put into a garage, and the judge said, you've got to pay to get this car out before you can get it, and that was a final order. The judge did not retain jurisdiction in that case, and Lovett didn't file his appeal on time, and so it was found to be untimely. However, in this case, this was not an executed sentence.
What about the state's timeliness argument that any argument about allied offenses should have been raised 30 days within the appeal time from the original agreement?
I believe that the state is incorrect because that is not an executed sentence And I see some of the courts, I mean, some of the states' case law. If you give me, I apologize there. In Underwood, which is one of the cases that everybody relied on in this, it's the one at paragraph 22. It says our holding does not prevent RC 295308D1 from barring appeals that would otherwise challenge the court's discretion in imposing a sentence, such as whether the trial court complied with statutory provisions like RC 292911, the overriding purposes of felony sentence, 292912, the seriousness and recidivism factors, and or 292913A through D, the sanctions relevant to the felony degree. And this is the important part. It says, or whether consecutive or maximum sentences were appropriate under certain conditions. And as what Underwood said, their holding does not prevent the Court of Appeals from deciding whether consecutive or maximum sentences were appropriate. That is in paragraph 22. And as the court made clear that the sentencing hearing after a merits violation is a new sentencing, and what's in State versus Washington, another case that the state relied on, is that one of the lines is, furthermore, because sentencing after a community control violation, the defendant may argue whatever he likes at said hearing. That's from Washington. And they went on to say, nothing in Ohio's felony sentencing statute prohibits the litigation of murder at sentencing. This was at sentencing. This was a merit sentencing.
Sentencing was when he was initially sentenced in the first place and put on community control.
I would agree that it was one sentence, but as the trial court made very clear that each time there's a merits violation, that there's a new sentencing hearing.
He was sentenced at the time he would be sentenced to 9 years in prison for any violation. That was done at the initial sentencing hearing, right?
Yeah, but that was not an executed sentence. That was a potential sentence. That was a ceiling.
But that was for a violation of the pre-lenient sentencing in the first place, right?
Which
was community control.
Okay, he was sentenced to that, put on community control, but it's clear that wasn't a final sentence because at the first community control-based violation, the court did not sentence him to that. They said they're not going to do that. That wasn't this type of violation. It was only marijuana. At the second violation, Ortiz had been charged with felony 5 trafficking in drugs. The trial court said during the sentencing that those were opiates and that that was the most serious type of drug and so forth. But the trial court was incorrect. Ortiz was charged with selling cocaine, ma'am.
Well, at the time he was sentenced in the first place and given that hanging over your head of 9 years in prison, there wasn't any subsequent violation at that time. So the 9 years had nothing to do with whether it was marijuana or whatever, trafficking or whatever the subsequent conviction was for. The 9 years was imposed or said to be imposed before then. Is that correct?
The 9 years, he'd been sentenced to the potential of 9 years, and then he was sent to CBCF.
Right.
He violated, and the judge did not give him the 9 years. He gave him 30 days. And in that first sentencing, the judge explained very clearly that sentencing after a merits hearing is a brand new sentence, a de novo sentencing, a brand new sentencing. And at a sentencing, if you're going to have a sentencing hearing, what's the point if there's not going to be any due process where a person can argue what they want? In the case law, even the case law the state presents says that these can be argued.
Well, are you making a distinction between an agreed sentence where defense counsel and prosecutors agree to a sentence and what you're calling or describing as an agreed potential sentence? Is that where the disconnect is?
I'm sorry, I didn't understand.
Well, let's say there's an agreed sentence between defense counsel and the prosecutor, which requires consecutive sentencing, 9 years. Is there a difference between that scenario and what I think you're interpreting as an agreed potential 9 years?
There's a few differences.
So are you arguing this is not an agreed sentence between you and the prosecutor, rather it was an agreement that there was only a potential of 9 years?
It may have been an agreed sentence between us,
Right,
but the fact is, on the record, the judge said it was a potential, and I believe that what the court says overrides whatever we may believe, number one. Number two, I don't think that you can agree to something that's not authorized by law or contrary to law. I believe is what the case law says about those type of sentences, is that they're void.
Well, counsel, under that theory, then, should this be remanded, it should start from square one.
As far as sentencing goes, you mean?
No, square one. Those specs are back in place, everything.
I'm not sure about double jeopardy. I'm not sure about all that, Judge. I would have to.
Well, there is no jeopardy. You don't have the appropriate sentence, you have no jeopardy.
No.
The state's arguing it was a negotiated plea. A negotiated plea is honored by contract law. So you're suggesting the remedy is to go back and get a lesser sentence?
Yes, good. Yes, I'm saying that you cannot negotiate for something and have some. You cannot negotiate a contract that's against the law.
And
not
yet you
authorized
did.
by law. But we did. But it can't be enforced. It's a void contract. You can't negotiate to have somebody kill you and then go out and enforce the contract because it's not legal. It's a void contract. Could you let me know when I have 5 minutes left?
You're at 4:39 right now.
I got 4:39 left.
Oh, yeah.
Thank you.
You want to say the remaining?
Yes. That's okay.
Yeah, sure.
Judges, good morning. Brian Murphy. I'm Assistant Prosecuting Attorney with the Lorain County Prosecutor's Office. This case is about a 9-year prison term that became reality. Mr. Ortiz gambled on himself. He gambled that he was going to be able to survive his 5 years of community control sanctions without violating the terms that would get the agreed 9-year prison term imposed. The plea agreement benefited him in the short term. He didn't go to prison immediately, which he would have had he been convicted of a say it in a more colloquial term of a 1-year firearm specification. The possibility, though, became reality. And what he wants this court to do is get him out from under this agreement that he made. And there's no doubt about it, judges. This was an agreed 9-year term of incarceration. Let's not use the term prison sentence, because he was sentenced to community control sanctions, 5 years. Start that 5-year term at the community-based correctional facility. And if you violate the terms and conditions, he was told, on 3 occasions he was told this. 3 times he was told, if you violate the terms and conditions of your community control sanctions, the penalty that will be imposed was the one that you negotiated through your counsel for a 9-year prison sentence.
Was there any discussion of merger or allied offenses at that original sentence?
Absolutely not. Go back and look at the record. Go back and look at the sentencing memorandum that his own attorney wrote for the trial court. Never once did it address the issue of allied offenses. Not once.
So there, on the other hand, there was not an agreement that these were not allied.
Correct. And the case law says under Rogers, it's the defendant's burden to demonstrate allied offenses of similar import. And if the defendant doesn't demonstrate allied offenses of similar import, all that's left to do is for the trial court to sentence on each and every count for which the defendant either pleaded guilty or no contest in terms of a plea agreement. That's all that's left for the trial court to do. That's its legal obligation to sentence on a count or every count for which there's a plea of no contest and a finding of guilt or a guilty plea.
Is a sentence that does not consider whether or not convictions are allied offenses of similar import unauthorized or contrary to law?
I'm sorry, could you ask that again, Judge?
When a court imposes a sentence without considering whether or not the various offenses are allied or of similar import,
Okay.
Is that sentence contrary to law or unauthorized by law?
No. Under Mangus, I believe is the case, burden is on the defendant to bring forth that issue. When the defendant doesn't bring forth that issue, and in fact couldn't have brought forth the issue in this case, there is absolutely no way to assert allied offenses of similar import in this case. And defense at this point, Mr. Ortiz is going so far as to say every count should have been declared, ruled an allied offense of similar import. If every count were an allied offense of similar import, the most the greatest prison term of incarceration that could have been imposed by the trial court was 36 months for a third-degree felony. Now that 36 months is 6 years away from the plea agreement that Mr. Ortiz, through his counsel, negotiated. This was an recommended, I should say, I don't want to use the term agreed, because this was a recommended sentence. It was recommended to the trial court. I mean, that's the language that the case law uses. It was a sentence that both the prosecution and the defense recommended to the trial court, and the trial court imposed it. Under 2953-08, this court doesn't have jurisdiction. And the reason it doesn't have jurisdiction is the underlying rationale of not utilizing judicial resources efficiently. He got exactly what he bargained for, Mr. Ortiz. That's exactly what he bargained for. I'm not going to prison immediately. Again, he bet on himself, and now he's asking this court to somehow undo the bargain that he enjoyed initially, but that has now had some drastic consequences, admittedly. But there is nothing unauthorized about this sentence. This sentence was authorized by law. 36 months. 36 months and 36 months on 3 third-degree felonies. There's nothing unauthorized about that. That's exactly what the statute allows, and that's the definition of authorized by law.
Is there an issue as to whether or not the court adequately addressed the statutory factors for consecutive sentences?
No, there's not under the case law. The court doesn't have to justify consecutive sentences in this case, because the only way to get to 9 years was to impose consecutive sentences. And when Mr. Ortiz and his lawyer walked out of court following the plea agreement, the change of plea hearing, and following the sentencing, they knew well that the only way to achieve 9 years was to impose consecutive sentences. That's a waiver. You know, we ask jurors to come into court and use their common sense when they go and deliberate. And sometimes I think when we then get outside juries, we decide that we're going to get very hyper-technical. This is a common sense conclusion. We have common sense to say the only way I could achieve 9 years on an agreed, on the recommended sentence that the trial court imposed is to give consecutive sentences. Whether it be 24, 24, 24, 12, 12, if my math is correct there, another 12, whatever it be. But however we can achieve that 36, the 108 months or 9 years, that's how it gets achieved. If he's telling you that he's appealing this sentence, he's untimely. He's absolutely untimely. What he's appealing really is the penalty imposed at that community control sanction hearing, violation hearing. The penalty, not the sentence. The penalty imposed was the 9-year term of incarceration. The sentence, as the court has noted, was imposed back in December of 2016. And I'm aware of the case law that says, you know, there's a kind of a de novo sentencing. Okay, fine. We've got to do the 29-29-11 factors and all those other things and post-release control advisements again. But don't lose sight of the fact that this is the recommended sentence imposed by the trial court. When the trial court decided that it was going to impose under 2929, it's 18, the community control sanction violation statute. When the trial court decided it was going to impose the penalty of a prison term of incarceration, that term of incarceration which is allowed to do by statute, it had no other option than to impose 9 years. And the only way to do that was to impose consecutive sentences. And it didn't have to make those consecutive sentence findings because Mr. Ortiz agreed to serve consecutive sentences.
Well, if the sentence in this case was really 5 years community control, could he have agreed to anything as a consequence for a community control violation? Could he have said, I'll take 20 years if I violate community control? I'll agree to 20 years, even though it has nothing to do with the underlying...
Under the particular charges of this case, no. 20 years would have been unauthorized. My math worked out to be 14 years, I believe, was the, I'm sorry, I think 17 years. So off the base charges of the indictment, 16 years plus the 1-year firearm specification. So 17 years. So anything over and above 17 is unauthorized by law. It exceeds the mandatory time. So he couldn't have agreed to 20, no. I mean, he could have, and it's contrary to law. That would have been a sentence contrary to law. Again, the state's actually going so far as to say that he waived, that Mr. Ortiz waived his protections under 294125. The way to have asserted those protections of allied offenses of similar import would have been not to agree to this plea bargain. That's the way to do it. It's not to come back a year later after you violated your community control sanctions twice and said, oh, now we need to address allied offenses. And Judge Kellen, I think you're right. Is what he's asking to do is void the sentence. If you void the sentence, you go back. He doesn't get the benefit of his plea bargain. But that really shouldn't factor into this decision, because the decision here is you're without jurisdiction. This appeals court, by statute, 295308, cannot review a sentence that was recommended by both parties. And there's also some indication in appellant's brief and Mr. Ortiz's brief that the court was involved in the plea bargaining process. The record doesn't reflect that. The trial court imposed the recommended sentence from the parties. So the prosecution and the defense reached a plea agreement in which a mandatory 1-year prison term essentially was removed from over Mr. Ortiz's head, and he pleaded guilty and received the benefit of not going to prison immediately. But once he violated those community control sanctions, all that was left to do by the trial court was to impose 9 years. If the court has no other questions, the brief, I think, I realized in reviewing it over the past couple days, probably came to the wrong conclusion, and the conclusion isn't to find his argument meritless, because this court can't even consider whether allied offenses are at issue here. The actual conclusion is to dismiss this appeal for a lack of jurisdiction. The one other thing I'll just note quickly, there was some talk of an executed sentence and a final sentence. I'm aware of no precedent. I'm aware of nothing that says there's a not final sentence or an unexecuted sentence. The sentence is executed the moment that journal entry was signed back in December of 16. That there's a sentence. That's the final sentence. It's 5 years community control sanctions, with an agreement that if there's a violation of those sanctions, the potential, and there was some talk too about potential, the potential prison term would be if imposed. So in other words, the trial court judge on the first community control sanction decided not to impose the 9-year prison term. Now the state didn't agree with that, the record shows, but he didn't impose it. Once the trial court decided to impose the potential sentence, it had no authority other than to impose 9 years. It wasn't up to 9 years, it was 9 years. Thank you, judges.
Attorney Martin, we have about 4.5 minutes, sir.
Thank you. Judges, the courts, this court, all the courts are used to defending people who put themselves in vulnerable positions, such as in an adhesion contract. This can be looked at as an adhesion contract. What choice did Adam have? And if you were going to protect others who put them in a vulnerable position and open to being mistreated and empowering others to mistreat them, then you should protect Adam Ortiz, because yes, he was desperate. And yes, he did want to stay out of prison. And yes, this was his only option. And as such, it is an adhesion contract. He had no bargaining power at this point. He put himself in a vulnerable position. Now, the prosecutor just talked about State versus Rogers. Well, the difference between State versus Rogers in this case is in State versus Rogers, the court did not say there was a waiver. The court said that Rogers did not expressly waive his right to argue merger. And the court has also questioned and asked enough questions that I've heard that the court is aware that there was no express waiver in Ortiz's case either. And Underwood stands for the proposition that sentence is authorized by law and is not appealable within the meaning of RC 2929 only if it comports with all mandatory sentencing provisions, which includes merger. And you know, I know there was one part in the prosecutor's brief where we talked about not authorized by law, and we laid out 3 elements. And one of the elements was that this is not authorized by law. As the brief went down, there was and it was clear that it was supposed to be the 3rd element. Not authorized by law became somehow contrary to law, but it's clear that we argued that this was not authorized by law. The Underwood court said, I'm sorry, I apologize.
Why wasn't all that stuff negotiated before when you were doing the plea? Why wasn't all that addressed before you came up with a recommendation to the judge?
We were in a position where we had to, it was an adhesion contract, just like I said, Judge. We were in a position that we either take this or Adam goes to prison, and Adam didn't want to go to prison. And so he put himself in this vulnerable state. And yeah, he agreed to it. The same way people agree to adhesion contracts that this court doesn't enforce all the time.
But that would mean, I go back to what I asked you before.
Okay.
Taking that and the way you're expressing it now would mean that there was no contract. It would go back to square one with all of the charges and the gun spec.
And I've thought about that, Judge, and you'll see in my brief I've asked this court to actually sentence Adam. But in that case, if we were to get a sentence that were similar to others in the similar circumstances, I'd be glad to go back with
But you didn't argue that. You didn't argue that.
I did argue that. I did argue that this wasn't similar.
I take it back.
I did argue that
Yeah.
because Robles, the guy who actually killed McDowell in this case, got 6 years. Adam got 9 years for cleaning up his grandmother's house.
Adam got 9 years for violating his sentence, though. There's a difference between the initial sentence, which was 5 years of community control. He came back and did additional stuff afterwards, which wasn't part of that initial 5 years, right?
Right, but the trial, oh, sorry, go ahead, Judge.
So even if you went back and resentenced him, which really is what you're asking.
Yeah, well, Judge, what he was convicted of, his probation violation was felony 5, trafficking in cocaine. Adam had no prior felony convictions at all. I mean, to give him 9 years, it's disproportionate. You'd be hard pressed anywhere in this state to find somebody who got 9 years on these type of charges.
But he got 9 years for the community control violation.
And then the community control violation was a felony 5, trafficking in drugs. He should have got a year, Judge.
That was a different case.
But you're saying he got, he put himself in a vulnerable position, the same way anybody who agrees to an adhesion contract would.
Well, he'd have been out by, I mean, he took 2016, 5 years if he'd done the community control, that would have cut off when, 21? So,
Yeah. But he didn't.
yeah.
And now we're here, and Underwood clearly states that any time consecutive sentences aren't appropriate, that we can appeal, and we're here on appeal, Judge, and we're asking this court to give Adam a sentence that's more proportional to others in the same circumstances. That's all we want.
And that being the case, then you used up your time, and the court will take the matter under advisement, issue a written decision between both sides, as well as post it to our website and that in the Supreme Court.
Thank you. Thank you, Your Honor.